Welcome back to the Constitutional Clarion. Having done a series of videos on coronations and kings and the like, I'm now moving back to something that falls within the core area of constitutional law in Australia, and that is the proposed referendum on an Aboriginal and Torres Strait Islander voice to Parliament and the executive government. So what I'm going to do in these videos is go through some of the arguments that have been made about it and look at the legal aspects of those arguments. Now in this first video, I'm going to talk about the argument that is often made about equality and division and about introducing race into the Constitution. So the argument runs that the Constitution treats all Australians as equals and that the Voice Amendment will undo that by introducing division and inequality into the Constitution, with one group, based on race, being given greater rights than other Australians. Now, does this claim actually stack up to scrutiny? Well, first of all, we need to understand that the Constitution does not treat all Australians equally. As the High Court has sometimes said, there is no general principle of equality in the Constitution and no implied principle of legal equality under the laws of the Commonwealth. Indeed, as judges have pointed out, the Constitution actually directly and specifically treats people differently. And it does so in some of the most important areas, like in terms of voting under our Constitution. Chief Justice Gleeson in the Mulholland case pointed out that, and I quote, "Voters in the smallest state in terms of population elect the same number of senators as voters in the largest state. In this respect, the value of votes is unequal. That inequality is one aspect of Australian democracy which, exceptionally, is enshrined in the Constitution. Where the Constitution contains an express provision for one form of inequality in the value of votes, it dictates at least some caution in formulating a general implication of equality on that subject." End of quote. Now, that inequality in the value of votes is most obvious in the Senate, where each state, regardless of its population, gets an equal number of votes. But it also applies as well in the House of Representatives, where each original state is guaranteed a minimum of 5 seats in the federal parliament, regardless of whether that's justified by its population. The consequence of that is that if you count it up, Tasmania gets almost 4 times as much representation in the federal parliament as New South Wales does. So a Tasmanian vote is worth almost 4 times as much as the vote of a person from New South Wales. Now, that's not necessarily a bad thing. It does ensure that people from the less populous states can have their voices heard adequately in the Commonwealth Parliament and that their needs are not neglected by the majority. But it's certainly the case that the Constitution does treat people differently. Now, this constitutional inequality of treatment is also reflected in the referendum provision itself. Section 128 of the Constitution requires that to pass, a constitutional referendum must not only be approved by a majority of voters across the nation, but also by majorities in at least 4 out of 6 states. Now that means that the will of the majority of the people can be overturned by majorities in only 3 states which have a smaller population. For example, in 1977, there was a referendum that achieved a very good majority. 62.22% of the people voted for it. It was a referendum that would have ensured simultaneous elections for the Senate and the House of Representatives. So instead of a Senate having a fixed 6-year term with half the Senate changing over every 3 years, you would have a Senate that was worth 2 terms of the House of Representatives, and you'd always have elections on the same date. Now that was approved by a significant majority of Australians, but because it failed to pass in 3 states, Queensland, Western Australia and Tasmania, the referendum failed overall, despite having majority support. This constitutional requirement of a double majority therefore potentially amplifies the voices of those in the least populous states, regardless of whether the subject of the referendum has any particular effect on those states. In that particular case, the simultaneous elections referendum affected all states in exactly the same way. It was a matter of general application, which didn't discriminate against any one state. In addition, in section 128, there's another provision which says that no constitutional amendment can be made to diminish the proportionate representation of any state in either House of Parliament or their minimum number of representatives in the House of Representatives, or even to alter the borders of the state without a majority of electors in that state approving it. And in this case, this restriction is focused on amendments that directly affect the representation of the state or its boundaries, and the support of that state is therefore required for the referendum to pass. Now, to take another example, have a look at federal finance. Section 96 of the Constitution permits the Commonwealth Parliament to make additional payments to support those states that need it. There's no requirement of equality in the way that the Commonwealth funds programs in the different states, even though there is a requirement in the Constitution that taxation be applied equally across the various states. So why the difference? Well, as the High Court has said on a number of occasions, equality does not mean treating everybody in exactly the same way. Where there are relevant differences between groups of people, those differences need to be taken into account. Now, those differences might include age, for example. You wouldn't treat a child in the exact same way as that you would treat an adult. Or it might be other things like citizenship or mental capacity. Sometimes people who are disadvantaged need to receive additional help to support them so that they have the same opportunities as others. And we are all generous enough to accept that. States, therefore, are funded by the Commonwealth not on the basis of an equal amount of funding per head of population in each state, but on the basis that the people living in each state should be able to receive the kind and level of services of the same standard across the whole country, because we are all Australians. Now, those who assert that the Constitution treats all Australians equally, regardless of race, also betray their ignorance of the White Australia policy and the explicit inclusion in the Constitution of a power to make special laws with respect to people of particular races. As Chief Justice Brennan noted in the Kruger case, legislative inequality is contemplated by both the aliens power in 5119 of the Constitution and the race power in section 5126. He added that these powers, quote, destroy the argument that all laws of the Commonwealth must accord substantive equality to all people irrespective of race. One might also think that politicians would be aware of different treatment in section 44(1) of the Constitution, because it disqualifies from Parliament people who hold dual citizenship. The Constitution does not treat everyone the same, particularly when they want to run for Parliament. Aboriginal people, of course, were treated unequally under laws made by Parliament in respect to things like voting and also access to pensions. They were not included in the population count for certain constitutional purposes until section 127 was repealed at the 1967 referendum. That referendum did not result in all people being treated the same and race being removed from the Constitution, as some people seem to think. The race power remained in the Constitution and was indeed expanded to allow special laws to be made with respect to Aboriginal and Torres Strait Islander people. The coalition government at the time did consider the complete removal of the race power, but decided that it might be needed in the future and should therefore be retained in the Constitution. One argument that was made in the Cabinet submissions, and you can see them on the website of the National Archives, was that the race power might be needed to resettle the people of Nauru if their home became uninhabitable. The coalition in the 1960s took the view that the Constitution should permit people to be treated differently by reference to their race if this was needed in the future, including for the purposes of aiding and supporting them. Despite this different treatment in the Constitution, the High Court decided in a case called McCloy in New South Wales that the people of Australia are able to enjoy, quote, equality of opportunity to participate in the exercise of political sovereignty. Now that's really important for three reasons. First is the notion that Australian sovereignty is no longer held in the United Kingdom or by the Westminster Parliament, but by the Australian people, populous sovereignty. And that includes Indigenous people as well as non-Indigenous people. We all share that sovereignty as the people of Australia. The second important thing that it says is that all of us should have an equal opportunity to exercise that sovereignty by participating in the political system, including by raising our concerns with Parliament and the executive government. Thirdly, the High Court recognised that that equality has to be substantive equality rather than simply formal equality. It again recognised that treating people the same when there are genuine differences does not result in equality or fairness. The High Court in the McCloy case accepted that for equality to be substantive, then some voices may need to be quietened, for example by putting caps on political donations which would limit the influence of the rich, in order that other voices can be heard. And this is because wealth can be an obstacle for equal participation in the political system. For example, if a rich person buys up all the advertising time on television before an election or buys up all the access to billboards so that no one else can put their position out there in the public realm by those means of advertising, then that's problematic. So in the McCloy case, 4 judges said that the risk to equal participation posed by the uncontrolled use of wealth may warrant legislative action to ensure or even enhance the practical enjoyment of popular sovereignty. But it is not only a matter of restricting the voices of the wealthy or the loud so that others can be heard. Sometimes the alternative approach is needed of enhancing the voices of those who are disadvantaged and would otherwise be unlikely to be heard. This was addressed by the Canadian Supreme Case in a case called Harper, which the High Court quoted with approval in the McCloy case. In Harper, one of the judges said, the state can equalise participation in the electoral process in 2 ways. First, the state can provide a voice to those who might otherwise not be heard. Second, the state can restrict the voices which dominate the political discourse so that others may be heard as well. Now, so far in Australia, in places like New South Wales, for example, we have taken some action to restrict the voices of some so that other voices can be heard by putting limits on political donations and political expenditure. But what we are now seeing with this proposed referendum is taking the other side of the equation by enhancing the voices of those who might not otherwise be heard so that they can fully participate with equality in Australia's system of representative and responsible government, which finds its source in populous sovereignty. We all know that in Australia, some voices have disproportionate influence on government. They are the voices of the media moguls, the voices of those who make large political donations to political parties, the voices of those who wield economic influence, like the miners, the business groups, the ACTU, and those who wield organised social influence, like churches and ethnic groups. Now, amongst all those loud groups and strong influences, it's hard to hear Indigenous voices. They simply don't have the economic power or indeed large enough numbers to affect voting numbers. and therefore they don't gain the equivalent level of influence as those, particularly those with well-supported lobbyists, are able to achieve. An organised voice with a permanent existence and defined function of making representations to Parliament and the Executive is one way to address that disadvantage and to ensure that Aboriginal and Torres Strait Islander people are able to enjoy equality of opportunity to participate in the exercise of political sovereignty. So this referendum proposal is intended to enhance the substantive equality of the people rather than undermine it. The voice referendum is not about giving greater political rights to one group over another. All Australians, you, me, everybody else, bodies as well, can make representations to the Parliament and the Executive Government. And our capacity to do so is also protected by the Constitution, that implied freedom of political communication. But as we all know, it is hard to be heard amongst the cacophony of loud and well-resourced voices of lobbyists and businesses and unions and others. So what is this voice referendum about? It's about enhancing the ability of Indigenous Australians to be heard. Thank you for listening. I hope this was useful to you and helps you to build up the information you need to be able to make an informed decision on the referendum. Stay tuned for other videos where I will address some of the other tricky issues about the voice referendum. See you next time.